Debate continues over a Supreme Court ruling that allowed lesbians, gays, bisexual, transgender and queer, that is LGBTQ, to form and register their own association. While majority of the 5 Supreme Court judges had their way by ruling in favor of the LGBTQ community, minority judges had their dissenting voices heard by insisting that it made no sense for the majority judges to allow for the formation of an illegal association when the Penal Code expressly criminalizes any sexual activities between individuals of the same sex or gender. Shadrach Mite looks at why minority judges rejected LGBTQ associations in Kenya.
5 Supreme Court judges comprising of Deputy Chief Justice Philomena Mwilu, Smokin Wanjala, Njoki Ndongo, Mohamed Ibrahim and William Ouko had the responsibility of determining the fate of same-sex associations in the country. Majority judges comprising of Justices Philomena Mwilu, Smokin Wanjala and Njoki Ndongo allowed registration of LGBTQ associations. The minority, who included Justices Mohamed Ibrahim and William Ouko, had their say through their dissenting opinions that lesbians, gays, bisexuals, transgender, queer and intersex activities are illegal. The 2 judges said they failed to understand why the LGBTQ persons should be allowed to form an association when the Penal Code expressly criminalizes any sexual activities between persons of the same gender. The majority judges ruled that it was discriminatory for the Non-Governmental Organizations Coordination Board to deny LGBTQ people opportunity to form associations to champion their rights. The judges further pointed out that it would be unconstitutional to limit the right to associate through denial of registration of an association purely on the basis of sexual orientation. However, Judges Mohamed Ibrahim and William Ouko in their dissent said the NGO board's refusal to allow registration of associations, which include the terms gays and lesbians, cannot be considered unreasonable, irrational or illegitimate. Sections 162 and 165 of the Penal Code criminalizes homosexual relationships, while Section 163 prescribes a penalty of imprisonment for 7 years for any person who has carnal knowledge of another person against the order of nature. In their ruling, Judges Ibrahim and Ouko said the moral foundations of our society serve as the basis for our constitution and the various statutes enacted by Parliament, adding that the laws criminalizing LGBTQ must be observed and respected. The 2 dissenting judges further ruled that if the people of Kenya decide to have these laws removed, then Parliament must enact, amend and repeal the Penal Code. Article 36 of the Constitution guarantees every Kenyan the right to freedom of association, which includes the right to form, join or participate in the activities of an association of any kind. Nevertheless, Justice Mohamed Ibrahim ruled that the rights of association are not absolute and can be limited as provided under Article 24 of the Constitution. Justice Ibrahim further pointed out that the drafters of the Constitution did not intend for the formation of groups whose activities or objectives were against the law. On his part, Justice William Ouko said the NGO board had justifiable reasons for refusing to register LGBTQ associations, for the board could reject an application if it was satisfied that the proposed activities or procedures of the association were not in the national interest, were repugnant or inconsistent with any law, or were otherwise undesirable. 2 other Supreme Court judges, Chief Justice Martha Koome and Justice Isaac Lenaola, did not sit on the bench because they had previously handled the case at the High Court and Court of Appeal. Meanwhile, U.S. Ambassador to Kenya Meg Whitman has refuted claims that the U.S. government influenced the Supreme Court ruling in order to force Kenya to adopt LGBTQ. Shadrach Mite, KTN News.
Straight away, let me bring in Duncan Okach, a lawyer, just to make us understand what that ruling is. Wakili, thank you for joining us for this discussion virtually, allowing registration of the association at the same time. Majority of the judges saying that, you know what, you cannot go ahead and practice it. And Kenyans, you know, I've sort of like associated this with a very interesting analogy. You know, you can register probably a group of a gang, register your association, but no, you cannot actually rob Kenyans. So what does this ruling mean?
Thank you so much for having me. Ideally, I think this ruling by itself is very unsettling. And I think the reason for that is because it seems to be a ruling that does not resonate with the religious beliefs, the customs and traditional beliefs of the people that this ruling is supposed to rule or to be subject to. And the reason I say so is because ordinarily we make laws for ourselves. The laws do not make us. So once we have laws in place, there is a proper process of repealing those laws. However, the Constitution says that any law that was in existence or remained in existence, or even is created and goes against the Constitution, is null and void to that extent. So at this particular point, the question that begs is, we have a law in the penal code that is 162 and 165, but we have the Supreme Court, which is the Supreme Court of the land. And laws can also be made through the courts. So this Supreme Court has now told us that it is proper and legal to form an association. But unfortunately, that association is an association which in itself will be promoting an illegality in all senses.
So Akili, is it that probably the Supreme Court sort of like, because some people have looked at it like sort of like legalizing this association through the back door, and how can a Kenyan actually challenge the Supreme Court ruling?
There are ways of challenging a Supreme Court ruling if you are not agreeable to it. Remember, the Constitution says that the Supreme Court decision is supreme and you cannot go to any other court to challenge that. However, decisions of the Supreme Court do not bind the Supreme Court itself. They can actually vary that decision today, tomorrow, 5 years, 10 years, 20 years to come. You can as well do what I've seen the Christian Professional Forum, what they've done. They've already filed a review. You can tell the Supreme Court, wait a minute, we need you to relook into this issue. But remember, the Supreme Court in its decision was saying, what is before us is not the legality of the issue of homosexuality, lesbianism, that is LGBT. They tried to say that what was before them was the question of the formation of an association. However, it is very difficult for a Kenyan to now say that you can deal with one part and leave the other. Because the moment you'd say that it is proper to form an association without looking at the nature of this association, whether it's illegal or an illegal enterprise, then whichever way you rule, you'll actually be sending a message towards the actual aspects which are prescribed by the law. So that's why people are saying the Supreme Court never said that it is legal to practice or to be a member of, to actually practice gayism, lesbianism, or any of those things. It may not pronounce itself on that. But the effect and consequence of legalizing and telling people you can form an organization, you can group up, you can recruit members, is actually leading to the presumption that the Supreme Court has now legalized LGBTQ activities.
All right. Thank you so much, Wakili Duncan Okach, for that short, brief, clear explanation on what the Supreme